The U.S. Supreme Court is taking on a case about race-based affirmative action in college admissions. So what's behind this case? ABC 7 News race and social justice reporter Julian Glover has been looking into it, and he is live now with what it all means. Julian?
Hey, good evening, Dan. Yeah, those for and against affirmative action in higher education certainly agree on one thing. The High Court hearing these cases is significant and has the potential to modify or even eliminate affirmative action in higher education as we know it. On Monday, the U.S. Supreme Court announced it will take up two challenges to affirmative action levied against the nation's oldest public and private institutions, the University of North Carolina at Chapel Hill and Harvard University, at issue whether the race of an applicant should be considered in college admissions decisions.
If the Supreme Court overturns earlier precedent, it means that affirmative action in admissions is over.
The case is being brought before the High Court argue public and private institutions factoring race into admissions decisions are in violation of Title VI of the 1964 Civil Rights Act, which prohibits schools that receive federal funds from discriminating based on race.
And we hope to see that the highest court of our nation once and for all settles the dispute, the legal dispute around race consciousness in higher education.
Affirmative action has long expanded college access for students of color and improved campus diversity.
Research shows that these benefits include reducing prejudice, reducing social distance between racial groups, cultivating intergroup dialogue skills and pluralistic orientation, encouraging comfort with people from other races. And so there's so many benefits.
However, the group Californians for Equal Rights Foundation believes the practice isn't fair for all.
There is a penalty that's disproportionately levied against Asian American applicants, both in the Harvard case and also in the UNC case.
The group is urging the High Court to narrow how affirmative action can be applied. Some are strongly against upending decades of legal precedent.
People in general want diverse student bodies, and affirmative action is one of the ways you get there. And if you take it away, it makes getting diverse student bodies much more difficult.
Both cases are organized and backed by conservative strategist and businessman Edward Bloom, who also backed the 2013 Supreme Court case that gutted protections in the Voting Rights Act of 1965, leading to nationwide voter restrictions. And there seems to be a solid consensus here, Dan. Legal experts believe this could be the first real test of the Supreme Court's new conservative 6-3 supermajority on the bench. Those justices could start hearing oral arguments in this case as early as this fall and then have a ruling come out in spring of 2023. Reporting live, Julian Glover, ABC 7 News.
Thanks, Julian.